Second-degree murder. That's what this case is about. You've all been fully aware of this now. We've been paying attention, asking a lot of questions, but it comes down to a very important decision. Or does it get any more important than this? A murder. Somebody died. And I hope we're not getting callous. And callousing is the fact that how many times do we watch a video of another person, Patrick, dying over and over and over again? It wasn't TV, it's not movies. This is a real man, a human being, who was shot in the back of the head back in April of 2022. And we watch it over and over. He's got a family, he's got loved ones. So I hope we're not callous, it's just something we see because we somewhat get immune to somebody dying over and over and over again. And we try and take a rational kind of look at it. And I think the other thing, when you look at it, it's a serious crime, but it's got one of the more simple elements, if you will. Because it boils down to just a few elements. There's a lot of other crimes you're not aware of, but elements are what we have to prove beyond a reasonable doubt. And so when it starts off, we talked about over and over again, this is the first element. Patrick died because of a gunshot wound to the head that the defendant did to him. And so that the other part is, yes, this is also about him, about what he did. Because Patrick is no saint. I'm not going to sit here and argue Patrick was a saint. He was drunk driving. He was resisting. He was driving without a driver's license. None of those are executable offenses. There are ways to deal with it. It's just because he committed a felony. He could commit 20 felonies. He could have had other felonies. It doesn't mean he deserved to die or he has to die. That's for juries. That's for other things down the road. The other thing is, I'm not going to sit here and say he's a horrible person. Yeah, he's got a great family. We heard about how he's an All-American, grew up in Grand Rapids. Yeah, that's wonderful. That's great. It's also fairly irrelevant. Because you don't compare, okay, one's good, one's bad, we'll just throw it up there. You have to base the case based on the facts. You'll hear from the judge that sympathy or prejudice shouldn't play any role in your decision. So you've got to base your decision on the facts that were here, the facts that were what the witnesses said, the videos, all the policies and procedures. That's what you have to base it on. Not, well, he's a hometown boy and want to do good, and we've got this bad guy who's drunk driving. It's not that simple. It is simple in terms of the elements, though. Clearly, the defendant killed Patrick back in April. And he had an intent to do so. Because part of the instruction you hear, there's maybe 3 different states of mind. But I'm going to stop at the first one. There was an intent to kill. And the intent to kill, please don't get wrapped up. Nobody's saying that when we left that morning that he intended to kill somebody. When he fired the shot, he intended to kill. That is clear when you put a bullet in somebody's back of somebody's head. So in terms of the elements they have to prove, the first 2 are proven, no question in your mind. Those are the 2. Those are the easy ones. So what does it come down to? Why are we here? Number 3. Number 3, was the killing justified or excused or reduced to a lesser crime? That is your decision. That is why you're here. And justified, I talked a little bit of cross the line clean. Words matter. And words matter in terms of, it matter, we're going to hear a lot of instructions, and sometimes jurors get wrapped up in terms of instructions that, this is the law, and we're in a courtroom, and somehow things change because you're in a courtroom. You don't lose your collective common sense. You'll hear that instruction from the judge. You have your own common sense. You have your experiences. The words that you use out there have the same meaning here. Justified. Done for a good and a legitimate reason. Excused. Removing the something you had to do. You're excused from school. You have a duty to go to school. You're excused from school. You're removed. So what is the duty here? You have a duty not to kill somebody unless it's a really darn good reason. That's the duty you have here. That's the duty any of us have here. There's no difference between a police officer or a civilian. You can't take a life without a darn good reason. So when you start looking at that, when you start getting into the evidence, I think there's maybe also a little bit of confusion in terms of the law. What is the law? Okay? What is the law, and the law impacting the policy? Because you've heard that. There's the policy of GRPD. You have to follow the law. Okay? The judge will tell you your job is to follow the law policy, and what the policy is, in fact, may impact how you interpret the law and what happened here. But you have to follow the law. So the law on the left The defendant must have honestly and reasonably, once again, words have meanings, honestly and reasonably. It can be two different things. You kind of think of the same thing, but you can have an honest belief, but it's not reasonable, right? There's a lot of people that believe that have an honest belief. We never landed on the moon. It was a big hoax. Nobody landed on the moon. We made it up. There's a sound stage somewhere in California that we made up a moon landing. It's an honest belief. Is it reasonable? So a lot of what depends on is what is reasonable. And what is reasonable is also defined. And there's two, you'll see the same thing. You have the policy of GRPD is not vastly different from what the law is. You kind of take a look at the reasonable person under same or similar circumstances, looking at the totality of the circumstances, looking at everything that happened. What led up to that decision to fire that shot? You have to take in everything from the start to the finish. And it's got to be reasonable through the entire time. We've heard that testified to on a number of different occasions. So you have to, what is the reasonableness when you break it down? And once again, dealing with the facts of what was presented here today, or here this week, that the time you're paying attention to. Well, maybe putting it another way, it was reasonable to shoot Patrick because he had the taser, he was outnumbered and exhausted. That's really the justification. That's the excuse. Okay? And that's an important thing because it's not that he pointed the taser. Nobody said that. The defendant took the stand, can't say that in a statement, never said he pointed the taser at me. He simply had the taser. That's it. The best we could get at was, well, maybe he was starting to turn and he thought he may be pointing at him. No evidence, no evidence, never said he threatened it, said he was going to use it, that I was going to kill you, said anything like that. He simply had the taser as one of the justifications of why I had to shoot. And the other one is, he was exhausted and alone, outnumbered. So, kind of taking that second one, let's take a look at that second one going from that perspective. Okay, why? Why were we in that situation? Well, it goes back to the chase. There's no dispute that, the defendant had the absolute right to try and place him under arrest. Okay? He was driving without a license. And that's the thing you have to look at it. At the time, he knew driving without a license and had a bad plate. Those are the only two reasons. Okay? There's nothing else. Nothing else that the defendant knew at that point in time. So you have to take it at that point in time, that's what he knew. Didn't know about the drinking, that came up later. So at the time, he makes the decision to chase, and we're going to play the videos. We've seen it ad nauseum, and that's a great thing now. You can go back in the jury room and play those. You can look at whatever you want. You have the ability to replay it, take different looks at it, pick whatever thing you want. Please take a look at it, go over it. You paid attention, but now you get to really talk about it. So the decision to chase happens, and he makes the tackle. Okay? He makes the tackle on that, within a minute, that's testimony, he's tired. He's exhausted and outnumbered. That's one of the first things he says in the statement. He's exhausted and outnumbered within a minute. Now, mind you, at 1 minute, this is one of the best fit officers in the Grand Rapids Police Department. And he's exhausted and tired within a minute? Well, apparently they should never chase anybody then, if that's the circumstances. And we're not saying, though, that police can never chase anybody. It's based on the totality of the facts and circumstances. And in this case, look at what's going on here. We talked about the use of force 9-1.5, relative size and stature, multiple subjects, relative strength, access to weapons. All those point against that decision to chase, right? Because from the get-go, he knew he gets out of the car, he knew he was bigger. We all, we heard from the testimony of Captain Cyber, well, you saw how he got jumped off, kind of moved when he spun. Got lifted off the ground. He was we didn't know if he had access to weapons. That's a scary thing because how many times over and over again did we hear about Grand Rapids Police talking about traffic stops, unknown traffic stops? You have to anticipate there are guns in the car. You have to anticipate that the people with the car in the car may have a weapon. But we have a person flying off chasing, not knowing about the guns, not knowing about there's another person, knowing this person's bigger and stronger, and yet doing that. But then using it, turning around and saying, well, I'm outnumbered and I'm exhausted because I chased somebody. That's troubling. That's troubling to use that as a justification from the get-go. There's plenty of policy, and that's why we talk over and over again, Exhibit 36. That's the one policy we see, a set-out policy. If you're looking at policy, how does that impact the law? That policy says, hey, if somebody's armed and dangerous, you're perfectly fine in following behind, having a plan, not tackling. It's bad tactics to tackle. And I thought it was ironic that, in terms we brought that up, that the defense then brings up, well, they're trying to chase. And they have to go over chases, but the chase that they talk about in Exhibit 31, they bring it up, you're responding to assist in a foot pursuit. Solo officer gave his last location and no further updates. You're first on the scene to assist. And what does that talk about? The officer's in trouble. The solo officer's in trouble, and so you've got to assist this officer in, he got himself bit off more than he could chew, which is essentially what happened here. So yeah, they train and you can chase, but it's basically you don't go running off. Von Queen says, yeah, I'm not going to advocate somebody go running off and chasing people down a dark alley. You're outnumbered, there's no business. When you don't know the situation, call for backup and do that. But now they try and use that as justification of why this all happened. The next part, the next major part, is the taser. You grab the taser. Okay? And these are screenshots. These are some frozen screenshots from the frame-by-frame video that you have an opportunity to take a look at. When you look at the frame-by-frame, this right here, the one on the left, is you can see the taser. That's when the moment the taser comes out. This is a little bit further behind because it's just about to be deployed, because you see the two dots on here from Nick Bloomfield in terms of that's where the shots are going to go at that point in time. So when the grabbing of it during this period of time, what's going on? Why would you make it? And Nick Bloomfield's the one that says, well, yeah, you can use a taser, but you got a whole big issue with weapons retention right here. And you see why. You see why is because that's exactly what happened. He grabbed onto it. He grabbed onto it right then because he's face to face. But once again, you get back up. It's not like you just look at it in silos. What did we talk about before? What did we talk about the criteria, if you will? Patrick's still stronger. Patrick's still don't know if he's got weapons. You're still outnumbered at this point in time. You're actually sticking, you're trying to stick a gun where this guy who you just tackled, had two hands on him, were on top of, gets up and walks away, and now you're trying to hold on to him with one hand, and then deploying the taser at the same time, and that's gonna be a good idea. And so this is, we had experts, this is Mr. Bloomfield saying, yeah, that's not a good idea. And you kind of see why that happened, but it also, once again, talks about policy going against. What does taser say? This is from the PowerPoint. We go over the PowerPoint. Here's what taser says about it, is that, employ other force options or disengage. Okay? So, Patrick did a bunch of bad things, but that, the defendant did some things that led to this firing a shot, and he's using those as justifications. Well, this all happened, ergo, I get to use deadly force. And that's where you get into Professor Stoughton and Nick Bloomfield. They're the ones, they don't disagree with everything that happened here. Yeah, you can get pulled over. Yeah, he had a right to arrest. But in these certain critical areas, there are critical mistakes that occurred here that a reasonable officer, not using 2020, a reasonable officer wouldn't make those same decisions. You don't try and chase somebody that's bigger than stronger. You don't try and bring a taser out holding on to with one hand in a position where he can grab the weapon, especially when taser says, hey, you can disengage. And the ideal footage that somebody has to use for a taser is 4 feet, even with the closed cartridges. Because we went over that. A closed cartridge, yeah, this Taser 7 had the ability to use closed cartridge, but closed is 4 feet, not an arm's length, which led to all this. So looking at the totality of the circumstances, you justify, well, I used a taser, I chased somebody, so I had to use, I shouldn't have, but I had to kill him then. That's essentially what they're arguing. So one of the things you also have to look at is the imminent threat analysis. And this is kind of interesting because one of the things they talk, you hear in terms of all the witnesses, the experts on both sides, Von Queen and Professor Stoughton on both sides, they kind of use the same analysis, right? They talked about this. The imminent threat means intent, opportunity. Okay? I think there's a motive. I think Von Queen had motive. There's a similar thing. So if you think about that, when does Patrick do an imminent threat? When does it happen? Once again, you just don't. Use the defendant's statement because okay, he didn't testify to this, but take a look at his statements. Those are exhibits 39, 38, 39. The last two things I just admitted. Because when you go back and I cross-examined on him, in terms of what did he think was going on. What was going on at the time, Patrick's trying to get away. Because these are his statements. He began to walk away, he proceeded to turn away, he ran away from the stop, he would not comply with commands and continue. That's, I think the last two are the key, continue to move his arms and legs in an attempt to get away. From the get-go, all this time before the taser grab, he's got the idea, yeah, Patrick's trying to get away. That's the defendant's perspective. That's what he says in his statement back in April of 2022. Okay, Patrick's not threatening me. Patrick's not taking a swing at me. Patrick's trying to get away. That's the whole basis. Even when it comes to the taser. And that's the thing. That's the key moment. Okay, that's maybe that's where the, okay, uh-oh, something more's happening here. He puts his hand on the taser. What is the defendant's impression? The defendant's impression is he moved it so he'd not be struck. And that also compares when you think about, you start comparing, you compare the witnesses. What do the other witnesses say? What does Wayne Butler, the neighbor? Wayne says from the get-go, yeah, Patrick's trying to get away. Wayne says, yeah, he's trying not to get tased. That's the whole thing. It's not an expert, that's just a normal civilian. A neighbor sitting there watching everything. He's not trying to get tased. You can tell that. That's a lot of what Seth and Professor Stoughton and Nick talk about. There's an intent to flee. There's no intent to harm. There's no assault going on here. He's trying to get away. You don't get to shoot somebody because they're trying to get away. That's not a justification. That's not an excuse. That's what the law is. And that's what the impression of everybody here, including the defendant, because that's a statement. So when you start looking at it, has the ability to have an intent to do great bodily harm. That's the imminent threat analysis. When does that start? Was it here? Because once again, you get to look at the pictures now, because right here, clearly, that one on the far side, he's moving away from him. I mean, that's obvious to everybody. So why now, just because he's got his hand on the taser, is he going to use it against him? He never threatened him. He's never tried to swing at him. And you go back to these. Look at the first two. He's got plenty of opportunity, right? He's arm's length away. Both hands are open. Take a swing, punch, do something. It's grab the taser, get away from him. So once again, how does a reasonable officer in this situation think I'm going to die? When a guy who's done nothing more than keep trying to get away from you, to keep trying to walk away from this. How does a reasonable officer get that out of this? And then you go to, and these are exhibits from the body cam, or excuse me, the cell phone video. You hear about, Professor Stone and Nick talk about, their opinion, based on generally accepted police practices, was that a reasonable officer in this situation would not have made the decision to fire. And what do they say? One of the reasons is, well, he was never in a good tactical, Patrick was never in a good tactical situation. And look at this. This is a good tactical situation when you're on the ground. He's on his back. Take a look at that. He's flat on his back with the taser at his side. Okay? He's not, and once again, what does Wayne say? Wayne kind of says the same thing. Wayne's not, once again, not an expert saying he's winning. The defendant's winning, I think he said. There's nothing coming from Patrick. Okay? Right here, this is the one thing they point to. Right here, just before the shot was fired, his legs get lifted off. His legs get lifted off the ground, but within a little over 10 seconds, he's back on the ground. So you break it up. So until the taser's grabbed, we have the defendant saying, yep, he's trying to get away. What happened in the next minute, 10 seconds approximately, that would make a reasonable officer think he's going to die? What did Patrick do? What did he do? He grabbed on the taser. That's the sole justification. He grabbed on the taser. Didn't point, didn't threaten, didn't say anything else. Once again, didn't throw any punches, didn't do anything like that. So why is a reasonable officer going to think, and that's exactly what Professor Stoughton and Nick said, a reasonable officer wouldn't have come to that conclusion. Generally accepted police practices, and generally accepted police practices are Grand Rapids policy. Because we heard that from who? Captain Simon and Captain Pierce, who basically said, we're CALEA certified. We're certified by CALEA. They give us, that's generally accepted police practices. That's, you have other agencies come in and take a look at things, and generally police practices, and that's what Professor Stoughton and Nick base their decision on, base their opinion on, when you take a look at all these facts and circumstances. Why would a reasonable officer think he's going to die when somebody's simply trying to get away, never in a technical situation by their opinion, and as well as the civilian witness who saw it at the same time? So it also comes into this part. I'm trying to play it, hopefully it works.
Let go of him! No, that ain't good. You can't talk to him.
Because that was one of the bases. That was the basis of Nick Bloomfield said, well, the other thing on top of it, the taser couldn't, there was no neuromuscular incapacitation. That was not possible because right there, because that's the second. And Brian Child says, yep, there's a second deployment. So it's been deployed twice. There was no probes that were going to fire out at that point in time. So he couldn't have been incapacitated. Well, they call him, David Blake saying, what the heck's going on? We need to, he doesn't hear anything, there's tunnel vision, there's, he's going to skip things and miss things. And his explanation at this point in time is, well, he could have, been out of breath. Out of breath, I mean, listen to it and watch. Drop the tape, and then he moves it away as well. There's plenty of knowledge that he knew exactly what would happen, but you also take a look at everything else. And you look at everything else, what happened there, what else? All these other things that he heard through this entire incident. Take a look once again at his statement. He heard everything. He heard the neighbor coming out of the house at the beginning. That's when the fight's still on. He heard that you didn't hear him, but that's still hearing, other units were on the way. He could not hear sirens later on. After the taser struggle, he knew that there were no sirens coming, that other cars were approaching. So he heard everything, and suddenly there's just one thing he misses, and that's on top of all the other perceptions he was making at that point in time. He saw, this is, he testified, here, he saw the red on the taser on what was happening. So when you look at all that, he was aware of anything, so suddenly this one thing he missed, that he wasn't aware that that taser had been deployed twice, so there was no chance of neuromuscular incapacitation. You have to ask yourself that. How is that possible? One thing, you just missed one thing out of everything he perceived. He perceived at the moment he fired the shot, in his statement, he says, yep, I checked the background, there's nothing there. So it's not like he says, I don't remember what happened. He says, yep, I was checking everything, I saw everything, I heard everything through this entire incident. So there's knowledge there that the taser was not able to be fired that would cause NMI. And the fact that it's suddenly maybe the NMI, that it could have caused pain, we heard over and over again. How many times did we hear from the various defense witnesses? Were you tased? Yeah, it was painful. It was painful as heck. It was burning, it was everything. Pain is not a reason to use deadly force. You can't use deadly force because you're going to be in pain. There's no instruction. You can use deadly force when you think you're going to be killed or you're going to be seriously injured. Pain is not part of that. Just because it's going to cause you a lot of pain. Burning the pain of 1,000 burning suns doesn't justify it. But they try and work that in now. And they try and add that in. And quite frankly, look at his statement. That was never the concern back when he wrote his statement back in April. The statement was he was afraid that he was going to get tased, there's going to be neuromuscular incapacitation, and then Patrick was going to grab his gun. It wasn't the taser that was causing the issue, it was the fact that he may get shot. So NMI said it, and then some Patrick's going to grab his gun. Why would you think Patrick's going to grab his gun? Patrick never went for his gun. He testified, never touched his gun, never tried to go after his gun, never grabbed his gun. But that was the feeling at the time. Which also going into policy, if you're trying to determine what policies should have an impact, you heard over and over again, what was the policy in 2020? Exhaust all alternatives before firing. Now I thought it's kind of interesting in terms of what they talk about. They keep on saying, well, in terms of if you make the decision to use deadly force, does that mean you have to go back down? That's not nobody's arguing that. Like I said, during one of the witnesses, if somebody comes out with a gun and points it at you, you don't have to try and use pressure points, right? Nobody's saying that. But when you're in terms of a struggle over that lasts a couple, 2-3 minutes, yeah, you got to try something else. And what do we have here? We have arm strike, one arm strike, a bunch of knee strikes, taser gun. What does JRPD teach on this? Why are we going over that? 4 hours, they're recertified. That's what you take a look at. the exhibits, all the training records. They are taught for every year, going over all the pressure points, all the different stuns, all the different strikes, all the different things that are used to try and get control over a person who's not willing to be arrested. You don't need to use all this stuff. You don't need to do stuns and takedowns and pressure points. You don't need to grab somebody by the side of the jaw if they're compliant, right? You only do that is when they're not compliant. None of them are used. Zero. Not one. So what is the purpose of this policy that says exhaust reasonable alternatives when nothing happens? They don't use it. It's ignored. Doesn't even try. Arm strike, kick, taser gun. That's all we have here. And then that's part of the policy we talk about, require a warning shot. Now they say, well, it doesn't make a whole lot of sense that maybe stop is enough. Maybe stop is, we don't say stop or shoot, but there's some sort of warning, so we kept on saying, you drop the taser, that's enough. That scene doesn't, that once again flies in the face of the policy that says is a warning shot must be given, or a warning shot, warning must be given before firing the shot after you exhaust all reasonable alternatives. None of them were exhausted. There was no really warning. It was just a shot in the back of the head from a guy who was trying nothing more than to get away. There was no threat there. He wanted to get away. Whatever reason, he wanted to get away. We don't know why. We don't know why he made that decision. He was drunk. That could have played a role. But that didn't mean he should die on that day. So when you look at it, a lot of what we are basing on, it's two experts. Our two experts, Professor Stott and Nick Bloomfield. And they base it on generally accepted police practices. What would reasonable officers do under this situation? And when you look at it, they take a look at the whole thing. As you look at it, there's I think Professor Stott said, there's an imminent threat. A reasonable officer would think there's an imminent threat of somebody trying to get away, but that's very different than an imminent threat of somebody trying to kill or hurt or injure somebody. Those are two different things. And once again, that's also backed up when the one civilian who really saw everything here, Wayne Butler, he kind of said the same thing. There was no evidence that Patrick was trying to hurt or do anything. He was trying to get away. The primary act was resistance, an attempt to hit harm, and he didn't do harm. I think that's an important thing. There's a fight to the death, and that's why I showed those pictures. There's a fight to the death, and the most injured, you got maybe some redness on his wrist. You're gonna fight to the death, and they keep on talking about a fight. How is a fight? Once again, a fight is defined as throwing punches, doing something else. This was a wrestling match. The most I could say, all the witnesses said this was active aggression. Okay? He was pulling away. He was wrestling. The only thing we can say is, well, potentially, maybe he could have. The defendant thought maybe he was going to turn and fire the taser. There was never a tactical advantage. That's what they said. Never a tactical advantage. So why would you think that you need to do it at the moment and fire that shot? Because what happened over and over again? You saw Patrick try to get up once, defendant shoved it down. Patrick got up again. What did he do? He walked away. So this time when Patrick's trying to get up again, he gets shoved down. Watch the video. Take a look at that video. He gets shoved down again. He never got up, fully walked around the second time after they went to the ground with the taser. They were wrestling. Patrick went to get up. He was shoved on the ground, and that's when the fatal shot was fired. The defendant had tactical control. The defendant was on top of him the entire time. Why would you think you need to use deadly force under these circumstances? So what happens? If it's not reasonable, it's not lawful self-defense. That's the only thing that justifies it. That's the only way we get out of here without a verdict of guilty under these situations. There's not a reasonable officer that think that Patrick was trying to kill him based on what was here. So what does that mean? The defendant's guilty. This is a traffic stop. At the time the defendant knew what was going on. It was for a bad plate and no driver's license. What out of all this made him think he was going to die? He had his taser? That's not enough. He was tired? Yeah, he was tired. That would be great. You don't need to beat over the head that he was tired. He was tired because he put himself in that situation. There's no reasonable officer that would think he was going to die based on the facts and circumstances here. So the verdict that must come at the end is guilty of second-degree murder, and that's why I ask you to return the verdict of such. Thank you.